Thank you. Please be seated. This is an action entitled State of Ohio versus George Washington Wagner IV, case number 2018 CR 155, and today is June 30, 2020. This is a pretrial hearing. The defendant is present in court today. I will note he's appearing in civilian clothes and without any visible restraints. He is accompanied by his attorneys, Charles Knight and Richard Nash. Present for the state of Ohio is Rob Junk, the prosecuting attorney, Angela Canepa, special prosecuting attorney, and David Andrew Wilson, also special prosecuting attorney, and Ryan Scheiderer, special agent for Ohio Bureau of Criminal Identification and Investigation, is also present. The first matter which we'll take up is the motion to withdraw appearance of counsel filed by the Office of the Ohio Attorney General. That was filed on June 19, 2020. The court will note for this record that the court had previously appointed Angela Canepa and Anthony Pearson, who were each at that time Assistant Attorney General of Ohio. The court had appointed them as special counsel in this case to assist the prosecuting attorney in the prosecution of this case. The attorney Canepa subsequently resigned from the Ohio Attorney General's office, and the court has reappointed her as special counsel in this case to assist the prosecutor. That was by entry of June 4, 2020, and then by entry of June 24, 2020, the court also appointed David Andrew Wilson as special prosecuting attorney to assist in the prosecution of this case, who I understand is serving without compensation. Is that correct?
That is correct, Your Honor.
All right. Now, it's my understanding that the defense counsel have all indicated that they do not require the appearance of, or do not request the appearance of Carol Hamilton O'Brien, who is the one that signed the motion to withdraw on behalf of the Attorney General's office. She's identified as Chief Counsel and Deputy Attorney General for Law Enforcement. She was here at a couple of related hearings in related cases to give reasons for the Attorney General's withdrawing. My understanding, defense counsel did not request that, and the defense counsel has no objections to her withdrawing. Is that correct?
That is correct.
Or to the Attorney General's office withdrawing?
No objections to the Attorney General withdrawing, and we do not require her presence.
All right. The court's concern, of course, would be two things at least. One would be whether the Attorney General's withdrawal from the prosecution of the case would create any delays in the preparation of the case by the state, and therefore delay the trial. And number two, whether there would be any possibility that any of the material and information that the Attorney General's office has would not be turned over for any reason to the present prosecution team, and therefore would not be available for the prosecution nor available for the defense, whether this would be Brady material or anything of that nature. It's I've received assurances, I believe, that from the state that's not going to be the case, but I would ask Mr. Junker and or Ms. Canepa to give me those assurances here on this record.
Obviously, I've got a prosecution team in place. The court has appointed. The withdrawal of the Attorney General's office is not an issue. I've had discussions with personnel at the Attorney General's office. They have assured me that there shouldn't be any issues with discovery. In fact, they've given us hard drives and the process of making paper copies of things for us. We've got access to BCI, the special agency analyst, and it should not be a problem.
All right. Does the defense have any questions you wish of the prosecutors here concerning the withdrawal of the Attorney General?
I have no questions.
All right. Then the court will grant the motion of the Attorney General to withdraw from the prosecution of this case. A brief history of the case. The last time I believe we had a pretrial in this case was on January 21, 2020. Since that time, we have had the attorneys met for a discovery session meeting at the Ohio Bureau of Criminal Identification and Investigation. That was March 13, 2020. The purpose of that, as explained to the court, was to peruse the items of discovery and to help organize the discovery. It's my understanding that meeting did take place. The deadlines previously set, of course, for discovery and for the filing of dispositive motions have passed. The motion was filed, number 57 of the defense, to extend the deadlines for filing pretrial motions, and that, I'm not sure if that's been granted by entry, but it certainly will be. We do need to try to arrive at some date for the filing of those. Since the last pretrial, the state has indicated that it has given to the defense, is approximately 4 terabytes of discoverable material on a 10 terabyte,
If not 5.
all right, 4 or 5 terabytes of material on a 10 terabyte hard drive. When we were here on June 25 in a related case, I believe that's the correct date, the state, through Ms. O'Brien, brought with her and gave to the prosecuting attorney a shared hard drive, which was represented as having on it material, all the material that the different investigating agencies had given to the Attorney General's office. That has now been turned over to the current prosecuting team. So the question may arise whether everything on that shared drive is on the master hard drive, given to, a copy of which has been given to the defense. And Ms. Canepa is going to be responsible for making that investigation to make sure that all the material on the shared hard drive is on the master hard drive, copy of which has been given to the defense, and that she will conclude that investigation. She will add to anything that the defense has. If there's anything they do not have, as revealed by this shared drive, that she will supplement what the defense has by August 21. And of course, if it's all on there, it's on there. But by August 21, the state will certify that discovery is complete. Is that correct?
It is, Your Honor.
All right. I guess that was June 22nd that shared drive was turned over. I think I misspoke. I said it was 25th, but it was 22nd of June. So by August 21, the state will certify that discovery is complete. There is an indication that there may be some criminal rule 404B material to be turned over to the state. It's unspecified right now, and if there is such material in this case, the state will specify what that consists of to the defense counsel by September 8, 2020. Am I correct on that, prosecution team?
You are, Your Honor. We decided on a September 8th date for that 404B.
All right. A motion was filed by the defense pursuant to Rule 42E, a motion to proceed under Criminal Rule 42E concerning the appropriation of funds for the employment of defense experts. That's an ex parte proceeding determined by, as provided in Rule 42E, and the court will be taking that matter up with defense counsel in the absence of the prosecutors pursuant to the rule, and we'll be doing that today. A motion was filed also, motion number 58 and 59. Motion number 58 is a request for a bond hearing. Number 59 is a motion for an order requiring the prosecution to provide a transcript of audio recordings it intends to introduce at trial. Those two motions will be set for oral hearing. Kathy, I didn't ask you to do that before this, so we'll be doing that as soon as we go off the record, setting those a date for oral hearing on those. Are we premature to try to set a date right now for defense counsel's substantive pretrial motions, or do you wish to wait till these dates pass at which you're to get the certification of the completion of discovery and the 404B material?
Yeah, my preference is that I first get certification discovery complete before we file that deadline.
All right. All right, and I assume the state has no objections to that.
We do not, Your Honor.
Is there anything further to be put on this record on behalf of the state?
Nothing we can think of, Your Honor.
On behalf of the defense?
Nothing further.
If there's nothing further, then we will adjourn. All right.
You brought up that he was in civilian clothing, but you did not ask him how he's doing.
I'm sorry, what was it?
Ask him how he's doing today, and if he, is happy with his counsel and all that.
Maybe you're right.
I think you did that.
Thank you. Thank you. I appreciate your point of this. Mr. Wagner, I've been asking you because it is important to the court to understand how you're getting along with your attorneys and so forth, whether you're satisfied with their representation and so forth. So let me ask you those questions, which you may be tired of answering, but I want to make sure that you still feel the same way that you've told me before that you felt about this. Are you seeing your attorneys as often as you feel that you should and as often as you feel you need to? Are you satisfied with the services that they are providing on your behalf and in your defense in this case? Do you have anything else that you wish to say to the court? You can consult your attorneys if you want to before answering, but any complaints or anything else you wish to say? All right. If there's nothing further, we will adjourn.
Thank you, Your Honor.
You're welcome.
Progressing. Somebody been there for a psycho. Yeah, so we were just talking. Did you hear me report back there? Yeah, Rick,